As we continue to give the basis for our court challenge, I wanted to go through some fundamentals, some basics here. And one is about a written constitution, which applies to any country that has one. So, to go forward, Kent in his commentaries, Volume 1, page 453, quotes the following from the decision of the U.S. Supreme Court in Marbury v. Madison as finally settling the question as to the competency of courts to pass upon constitutionality of acts of the state legislatures. The powers of the legislature are defined and limited by a written constitution. But to what purpose is that limitation if these limits may be passed at any time? The distinction between government with limited and unlimited powers is abolished if those limitations do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. If the Constitution does not control any legislative act repugnant to it, then the legislature may alter the Constitution by an ordinary act. The theory of every government with a written constitution forming the fundamental and paramount law of the nation must be that an act of the legislature repugnant to the Constitution is void. If void, it cannot bind the courts and oblige them to give it effect, for this would be to overthrow, in fact, what was established in theory and to make that operative in law which is not law. It is the province and the duty of the judicial department to say what is law, and if two laws conflict with each other, to decide on the operation of each. So if the law be in opposition to the Constitution, and both apply to a particular case, the court must either decide the case conformability to the law, or disregarding the Constitution, or conformity to the Constitution, disregarding the law. The Constitution be superior to an act of legislation, the courts must decide between these conflicting rules, and how can they close their eyes on the Constitution and only see the law? One of the other things to be considered are property rights and fee simple. All land is held by the sovereign. We will not get into the debate about native land claims or whether it was correct or whether it was fair. We will come to the assumption that the land is now held by the crown, and all land must have a lord, because if there were no heirs to it and no claim to it, then it in itself would become sanctuary surrounded by other land that had laws and regulations. Anyways, the Great Seal of Britain is supreme, and we now have the land from the sovereign, who is the holder of the crown, or the sovereign of the crown. And now the sovereign has the power to dispose and alienate crown land. Domain is the royal prerogative of the sovereign. The sovereign instructs the governor and lieutenant governors through letters patent to apply the Great Seal onto the land grants, and it would be for Canada or the province. So, who is the sovereign? Well, according to Webster's dictionary, the sovereign's prerogative is a theoretical, unlimited discretion of the sovereign to act without accountability to the Parliament. And in the concise Oxford's dictionary, the definition of prerogative is the theoretical right of the sovereign subject to no restriction. So, all of our municipal councillors, our MPPs, our MPs, all swear an oath of allegiance to the sovereign. Letters patent are the prerogative of the sovereign. So, when presented, our legislators should always read them and respect them, because they are, in their capacity, subordinate to the sovereign who they've sworn an oath to. This is some of the things that we're bringing up in the court, and we're trying to educate people, and sometimes it appears maybe even educate the court. So that's it for now. There's more coming, and thank you for watching.